Hi everyone, my name is Tina Huang. I'm a director at Queensbury Law and also the leader of the Property and Disputes team. Today I'm going to be talking about what happens if you've been sued or charged. Now, here are 5 things you need to know. Firstly, which court is it? Is it criminal? Is it civil? Is it employment? Is it in a tribunal? Is it the disputes tribunal, tenancy tribunal, or other tribunal? Is it the employment relations authority or the court, the family court, district court, high court? They all have different procedures and rules, so you need to identify which court you're in to begin with. Secondly, timeframes. So generally with a statement of claim, you generally have 25 working days to respond with a statement of defence. However, if you've been served with an interlocutory application, which often comes with the statement of claim, then you have 10 working days to respond to that with a notice of opposition. The notice of opposition requires an affidavit in support, so there is quite a bit of urgent work that needs to be done immediately. If you've been served with adjudication in construction, that has tighter time frames, so you really need to get to see your lawyer ASAP. Also, if you've been served with a statement of problems in the Employment Relations Authority, you have 14 days to respond to that. Interlocutory applications are generally applications that are done under urgency, seeking interim relief or quick relief from the court because something is urgent or at risk. Most of those are done with notice. However, some ex parte applications are done without notice, often in the High Court or the Family Court, because something is at risk or there is protection required, often in family custodial or spousal issues. Generally, you'll be given an opportunity to respond before final permanent orders are made in those situations. Thirdly, think about the first court date. So in civil cases, you don't need to appear in court. Your lawyer can do that for you. And the first call date or the court appearance isn't for quite a while because you have rights to file a statement of defence and then replies. It goes to a case management conference and there's various steps to take. However, in criminal, you do need to appear in person. You also need to think about the interlocutory applications that are done faster, that have often court dates that come up in the week or 2 weeks to come. Just be assured that that first call date is not the actual hearing date. It's often put into a duty list where judges look at it and assess it for timetabling and set it down for hearing. So that first date is not the date that judge makes orders. So be aware of that, unless of course there are special circumstances and they're applying for urgent relief because there is risk that you're going to take off with money or risk of protection or safety issues. Fourthly, service. So most court documents need to be personally served on you, which means that leaving it with your spouse or your commonly used lawyer or housemate isn't going to work because they have to personally serve you. If it's a company, the registered address for service will be used and can be used to effect service. So if they leave it at the registered address for service, that service done. So be aware that the address you use online in the company's office is the address for service and you should check that regularly. Fifthly, disclosure. You are generally entitled to initial disclosure, whether it's in the civil or criminal court, and later you get further disclosure or discovery in the process. Next, if you're being charged under a criminal section, then that is a criminal matter and you do need to go to court in that first date. The first date is normally a duty list again, where the judges go through the various list and your matter will be called. It is not normally a place where the judge makes a conviction or sentencing order, and duty lawyers are available in court to assist you in this process. It is very typical for first cases to be given a remand without plea for 2 weeks because you need further time to get legal advice. So be aware that you will have time to arrange further legal advice if you need. Lastly, it is very important that you get proper legal advice, whether it's criminal, civil, employment, or tenancy matters, whatever it is, you do need to get proper legal advice. don't think to yourself, I've got 25 working days to respond, so I'll contact my lawyer after 20 working days. 5 days is not enough to prepare. I've had clients come to me on the 20th working day saying, you've got 5 working days to file this, surely you can do that. I've then found that actually they've been served with an interlocutory application on top and missed the first call date for that. So it's imperative you get legal advice as soon as possible. Contact your lawyer and the experts that can help. We're here to help. Thank you.